Okay, we're going to get started. So thank you so much for joining us today for our Fireside Chat and Charity webinar. Um, we will be doing a Q&A section as part of this session at the end after we have a bit of a kind of prepared presentation and questions and conversation. So feel free to use the Q&A feature to get your questions in. You don't need to wait till the end to get your questions in. Send them in as you think of them so you don't forget them. Get them in, but we will get to them at the end. We're not ignoring them. We're just waiting till the end to get to them. But like I said, go ahead and use the Q&A feature to get in as many questions as you can. And we will try to get to as many of those as possible. This session will be recorded. So don't worry, if you miss something, we'll send out the recording. It generally goes out a few days later, so probably early next week, as it is Thursday today. That'll be sent out to all of the attendees and people who have registered. So if you miss something, don't worry, you'll have that recording. I'm going to pass it over now to David to make some introductions.
Yeah, thank you, Hunter. Good morning, everyone. My name is David Hutniak. I'm the CEO of LandlordBC. We really appreciate you joining us today, not just to take advantage of this educational opportunity, but also to support us in this important time of the year where those of us who are in a better place can help those who might be struggling. And we've had a long relationship with Covenant House, and this event today is basically to support them, and I'll tell you a little more about that in a moment. We're really fortunate that we have two great panelists to conduct this fireside chat. I'm sure many of you will know both of them, our own Hunter Boucher and Grant Haddock. What I'll do is a very quick introduction of both Grant and Hunter, and then we'll continue with the program. Grant Haddock was called to the bar of British Columbia in 1992 and is the principal of Haddock and Company Lawyers. Grant's core areas of practice are residential and commercial tenancy cooperative housing law, strata property law, residential and commercial tenancies, human rights, and privacy construction law. Grant has acted for numerous housing providers and construction companies, appearing for them at all levels of court and at various tribunals. Grant has been a course leader and frequent speaker at our educational events for many, many years, and a great partner to LandlordBC. Hunter Boucher. Hunter is our Vice President of Operations. He's been with LandlordBC in excess of 15 years and has extensive experience in the rental housing industry with a focus on legislative issues and best practices. So these two gentlemen will be leading the fireside chat today and sharing some great information with you. Today's fireside chat will focus on several crucial aspects affecting you as rental housing providers. Today, we will cover notable judicial reviews that could impact the broader industry, costliest common mistakes and cautionary tales for rental housing providers like yourself, and beyond the big three, RTA, PIPA, HRC, other statutes to watch out for, again, as rental housing providers. I know this session will be invaluable for you, and Hunter already explained that you're going to have an opportunity to have your individual questions answered, time permitting, etc. So I too encourage you to place them in the Q&A function throughout the session as you think of them, and we will get to them later in the session. As I mentioned, this is a charity webinar, and the charity is our longtime partner, Covenant House, which has been at the forefront of supporting homeless youth, offering essential resources such as safe shelter and access to education and employment opportunities. By participating in this webinar, you are contributing directly to providing a stable and supportive environment for young individuals in need. Your donations today total $4,800. And when we announced this webinar, we said that we're going to match dollar for dollar up to $5,000. What we've decided to do instead is top up our offer And we're really pleased to say that together we're going to give Covenant House $10,000 to help them continue the really great work that they do. Every dollar matters to this vital cause, and on behalf of Landlord BC, we thank you for your generosity. In recognition of your support, each donor has been entered into a draw for one of two $50 Rona gift cards. And for those who generously contributed more than $100, we have an exclusive opportunity to participate in an additional draw for a pair of Vancouver Canucks tickets donated by Grant and Haddock and Company. And we will have all these draws at the end of our sessions, so please ensure that you remain throughout the entire session. As CEO, I've been doing this for 9.5 years, and the one thing I always have known about our members is that, they are always really generous, and whenever we need them to, support causes like this charity event or other charity events that we've done, our members always, are there to support. And I want you to take this opportunity to, personally thank the following members who donated $200 or more. Nick Nuri, and I want to apologize if I mispronounce names. I'm trying my best here. Lillian Oljum, Nina Ferratinos, Janus Industries Limited, Bird's Nest Properties, Ratzleff Development Corp., and Grant Haddock, who, in addition to the Canucks tickets, he also made a personal donation to Covenant House. So thank you for taking this opportunity to make a meaningful impact. And with your support, Covenant House can continue to build on its mission. We say this all the time, that we can never put on events unless we have support from our supplier partners, and their sponsorship is crucial to everything we do. This particular session is possible thanks to a generous sponsorship of Rona. And what I would like to do is invite Natalie Milosh, who is the National Agreement Manager from Rona, to say a few words to us. So Hunter, or Natalie rather, if you can unmute yourself and turn on your camera, please. Okay, the slides up there. Please go ahead and speak to our attendees today.
Thank you, David. Hello, everyone. As mentioned, I'm from Rona. I wanted to share with you, I think we're really fortunate to be able to help in the Landlord BC charity today. So really, really happy to be here. Nice to finally see you. I'm in Montreal, Quebec, so I hope I will be joining you at some point for an event in the future. So I wanted to go ahead and show again, maybe a lot of people know this info, but we are providing discounts to Landlord BC members in every Rona Lowe's and Rona Plus stores. So I wanted to highlight the fact that you're getting 15% on paint and accessories, 10% on decoration, hardware, electricity, plumbing, manual tools, 8% on portable and stationary and electrical tools and interior doors, and 5% on kitchen, ventilation, heating and cooling systems, maintenance products, seasonal and horticultural products, exterior doors, building supplies, forest product, windows, flooring, and appliances. So we have many accounts open for sure. If ever you're part of Landlord BC and you do not have an account open with us, we're asking you to send your company name, address, contact, name and phone number, and your email address to the email national.agreement@rona.ca below. So with providing that information, I will get the information and I will go put in the back all the discounts. So when you shop at Rona Lowe's or Rona Plus stores, when you go at the cash and you mention your account number or your phone number linked to your account, you will have automatically the discounts that are showing there. They will be automatically in reduction. So that's the day-to-day stuff. Let's say you have a big renovation or a construction you need to do. You can go to our pro counters in every stores, and we have a sales rep in BC also that can give you specific pricing for any project that you're doing. So that's really important to know, because we deal with projects all the time. If you need big amounts of wood, of gyps, of any building material, or even if you need, I don't know, 30 toilets or cabinets, we can give you privileged pricing for your project specifically. But you need to contact, you need to go to the pro counters in the Rona stores. So that's part of what we offer on a daily basis. If there's something in special that you want to purchase, the best price will always apply. So let's say it's 50% on something that you want. Usually you would get, I don't know, 10 or 15%. The 50% will apply. So you always have the best price possible. When you shop at Rona also, you can buy in bulk. So I don't know, you want moldings. There's multiple items that you can see on the website that you see bulk pricing. So you'll have already a discount that will be showing up. So that's something interesting also. I wanted to talk to you also about the fact that we're building kitchens, countertops. We have those items, those style of product. We have specific people, professional people in stores that are really, really good for those projects also. I also wanted to mention, because in some renting buildings, you might provide appliances to your people. So you need to know that with Rona, and okay, I work at Rona, they'll say that I'm sold already, but I'm a shopper also, and times are difficult. And let me tell you that appliances at Rona, the price is the best. We have a specific program called Marketplace, and it has the brand Whirlpool underneath. It's the best price you could have from anywhere. It could go to 20 to 25%. So if you have appliances that you need to buy, please do not hesitate. Go in the stores and they will do a quote. We negotiated pricing with every brand that we know. So we are really, really, really good at it. And if you have any questions, you need information or whatsoever, I'm always there to answer. And I can give you my phone number also. It's 514-668-0051. It's not on the sheet there, but or send an email to nationalagreement@rona.ca, and I will have the information and write back to you with the answer to help you out. So that's mainly what I wanted to share with you guys.
All right, great. Thank you very much, Natalie, and thank you to Rona. Just to repeat the email address to register for this program is national.agreement@rona.ca. You can also reach Natalie through that email address. And just repeat your your phone number one more time, Natalie. 514.
514-668-0051.
Perfect. Okay, great. Thank you very much, and appreciate you joining us today. And have a good rest of the day.
Thank you so much. Bye, everyone. Happy holidays to everyone.
Yeah, thank you, Natalie.
Bye-bye.
All right. So, Natalie, you can turn your camera off and please too. And okay, great. All right, so now we'll get Hunter and Grant to come on screen here and get their, okay, off mute. Grant, you're still on mute. Okay, perfect. All right, so the main event. What I'll do is I have a series of questions here that I'm going to, just give me 1 second, to ask both of you, and we'll, you know, encourage the two of you to debate where necessary. But let's start with the first question. And again, this is to both of you. So in British Columbia, we have one legislation that covers all landlords equally, regardless of portfolio size. Are there any recent changes that directly affect landlords with a smaller number of units? Can you gentlemen please jump in?
Who wants to go first?
We're both too polite. That's the problem. Well, maybe I can perhaps maybe mention a couple that we've mentioned recently to our members, and then we can talk about them. I think the first thing that comes to mind is the recent expansion of the direct request process. This is a process that's been in place in general for 12 years, I think, maybe a bit longer. It wasn't actually much longer, or much later than when I started at this organization that direct request kind of became a thing. But they were really limited just to the 10-day notice, and that was good. It was a significant improvement. But now the expansion of those to include specifically the 1-month notice for cause, which is where I think that the biggest impact is really a good step in the right direction. Perhaps maybe just a moment of background of what a direct request is for anyone who's on the call, maybe not isn't aware. A direct request is essentially dispute resolution. It's going through the residential tenancy branch's dispute resolution process, which generally is a participatory hearing. It's a hearing where you go and you present evidence and talk with an arbitrator and with a tenant, and try to make your case. And the residential tenancy branch hears thousands of those cases. They have in the past been rather underfunded on that. There's been some improvement there, but it takes some time to go through that process. So the direct request kind of takes it out of that channel, I suppose, and puts it into just a paperwork type of process. It is really just supplying documentation reviewed by an adjudicator, who then provides you with an order of possession and or a monetary order. It is meant to be quicker. It's meant to be more direct, as the name suggests, but it's also a bit easier because we know what we need to provide in those cases. With a regular hearing, evidence preparation is not always easy. That's why we partner with people like Grant at Haddock Company. Because it is sometimes difficult, but with direct requests, there's a list, and you literally just have to check off that you've included them, and then actually include them in your application. And generally, as long as you filled them out correctly, which sometimes is the hard part, you should be successful.
Right.
Well, just touching on, yeah, just one of the things that Hunter was saying there about, now this is not a legislation thing, but it's a practical implementation that the government did, which was throw a lot more money at it in the hopes of speeding things up. So I don't have any actual empirical data, just anecdotal data from the lawyers in my firm. So there's like 7 of us, right? Or 8 of us, sorry, 8 lawyers in my firm, and we're all doing RTB stuff. So we've got like a fairly, decent idea of how things are moving. So we believe that things are actually moving faster at the RTB. Like things are, like, instead of waiting months, you're at weeks. It's still too long, but it's getting better. So no one, of course, like if the government does a survey or whatever, it's going to come out like really rosy, like things are really speedy, and we all know that's not the case. But I do have to report that based on apparently what they've done with hiring adjudicators and trying to smooth things out, things are moving faster than they used to move. So that's a good thing. And I think that was something that Landlord BC was like advocating strongly for, which is helps us a lot.
Yeah, yeah.
We've been working a long time on that, and actually, yesterday afternoon, Minister Colon actually published hard data for RTB turnaround times, and you're correct, they still aren't where we would necessarily like them to be, but great progress has been made. I think he and the RTB deserve a lot of credit for being willing to share all that data, but we're hearing from our members as well that noticeable improvement, still some work to be done, but the $15.6 million that the province put into the RTB over a 3-year period, we're starting to see the impacts of that. And then some of the other changes like the one that Hunter just touched on, are again, we're seeing improvement, and I hope in a year from now we'll be in an even better place in terms of hearing times, etc. But thanks for that, Grant.
Yeah.
Okay.
I think there's there's certainly other things as well that we've seen over the last couple of years when it comes to improvements for smaller landlords. I mean, one of the ones this year, it's not perfect by any means, but of course the government has intervened for 2 years on rent increases, and this year, through fairly extensive advocating, that was increased to 3.5%. Was not at the inflation that it should have been. We know that for sure, but it was a significant increase nonetheless. And a lot of that comes from our when it comes to our advocacy efforts on things like this, it comes from really our feedback from our members in terms of shaping what our advocacy efforts look like, and we provide that. We do that advocacy effort. It's to all levels of government. And as things change, we continue to provide support to our members on that as well through things such as our helpline and our e-news. So you actually see that media release that David is mentioning in our next e-news. Of course, it's also currently on our social media. So be sure to stay tuned for that as well.
Yeah, it's interesting about scale because Hunter, we were talking yesterday about scale and about what membership and so on. And the thing about like we act for small landlords and big landlords, and some of them are really big. But at my firm, predominantly, got to be 75% of our clients are small landlords. Sometimes basement suite owners or small buildings. But the scale that you have to when you're approaching the RTB is the very same scale as when it's a great big place with like 50 units or 100 units or multiple buildings. And so the small landlords are facing the same uphill battle that the big landlords are, and there's no scalability on that at the RTB. But the point I think that we were talking about was that our membership is mostly small landlords, and my clientele is mostly small landlords, and we have to speak for the small landlords who are just trying to. Some of them, it's not even a business; it's just trying to get by with mortgage payments, but a lot of them it's an actual business for them. And to create, like for my firm, we're trying to create, economic solutions to help people through or navigate when it actually shows up on our desk, because it first goes to the help desk at LandlordBC, and if it's too thorny, it comes to us. But it's a bit of a challenge because we do know that not everyone's a big corporation, but even though you're not a big corporation, you're facing the exact same problems as a big corporation. So it's a broad-based solution that everyone gets to enjoy, but that's part of the advocacy of LandlordBC, is a broad-based solution for everyone to enjoy. And also my firm tries to find some common ground too, to provide solutions or legal solutions for everyone, to all membership to enjoy.
Great point. I guess you mentioned member feedback, Hunter, is important for advocacy. Certainly, it's not just for advocacy. We welcome member feedback for how we're performing on a day-to-day basis, and certainly we know the helpline is well used, and that's a great conduit for communicating, your thoughts and or concerns. So, we always encourage our members to not be shy, and generally they aren't, but, we're always here to listen to your concerns to help you operate a successful rental housing business. I guess next question here, gentlemen. Are there any cases or judicial reviews that could have an impact on our industry that our members should be aware of? Anything specific that the two of you would like to cover there? And I'll start with Hunter. Why not?
Oh, no, I was going to say Grant, but
okay, well, whatever, you guys decide.
Sure,
Grant, go ahead.
I don't know if this is it's not a case, but it's something that's changed with the RTB, which is the grounds for review.
yeah.
And this is a biggie, and I think actually it's a bonanza for lawyers. Because that's really why we're thinking, well, hooray, it's fantastic. So if you haven't been through the RTB process, if you lost, you have an ability to go to review, which is basically an internal review by some other adjudicator at the RTB who is called on to criticize a colleague under certain grounds. The certain grounds used to be, I think, only 3, and they were virtually non-existent in almost every single case. So I would, I've had clients say to me, oh, I want to do a review. And I'd say, don't waste your time and money doing it. You can try, it'll slow things up, but really what you're looking at is a judicial review. Now, the grounds for review is expanded, as I think it was September. I think that's right. And now that the grounds of review are basically fodder for lawyers, is to get in there and try to, figure out a way. And then from a policy perspective, I was wondering why they did this. And I don't know. I haven't read the notes, the Hansard notes. You can go and see how the debates went, if there was any debate about this. But what internally was happening with this policy change? Is it an attempt, or is it a response to too many judicial reviews clogging up the Supreme Court? Is this an attempt by the RTB to say, look, we need to have more ways that we can internally look at bad decisions made by our staff and try to correct that before it goes to the Supreme Court and we get spanked on it again for doing something incorrectly at our level. So the grounds now are, if I can, here there. Let's see. So unable to attend, that's always been around. New and relevant evidence. Now that is as far as I'm concerned, a wide open thing. I don't know how many times people have come to us, and we'll talk about it a bit later, mostly in the context of the 2 months notice, and said, oh, I didn't know I had to have that evidence there. I just thought I could come and say something, and then it wasn't accepted. And you get to a lawyer, and we're trained in evidence. We know what evidence goes in there and how to put it in, and it's a free-for-all as far as evidence goes in the RTB. But we've got the experience to say you need this, this, and this, rather than going in there and trying to guess. Material evidence submitted late or not before the arbitrator. I mean, that's just another wide open door. Administrative procedural error, that's more of a legal question. Technical irregularity or error, again, a legal question, wide open, I'd say, for smart lawyers to get in there, or crafty, sneaky lawyers to get in there and find ways to overturn these. Fraud, that's always been around. That's not a new one. Let's see, director did not determine an issue they were required to determine. That happens quite often. They don't answer the question that was before them. The director did not have jurisdiction to determine an issue, so that's been around for a while. So all of those are very interesting, wide open things, and we're looking at that as another tool in our belt to overturn decisions that we don't like. Now, don't forget, the tenants have the exact same right, and they're probably going to do that. And there's plenty of organizations like Track and Class that will go out there that do pro bono work for tenants who will also want to perhaps take advantage of this. So it's a two-way street. But for me, I'm looking at it as this might be a way to fix things that otherwise go to judicial review, And if anyone's been through a judicial review, you know the legal fees are somewhere between $10,000 and $15,000 for JR or more. But you know, normal JR is around 15 grand, and nobody really wants to pay that unless it is imperative that you win this case. So this might be a way to actually cut costs. So yes, it's another procedural step, but I think overall it's going to be a benefit to landlords and tenants.
Hunter, we have
Yeah,
been
I mean,
involved. We're part of a stakeholder group with RTB, and you know,
yeah, this is actually a pretty long coming change to the RTB, one that, I mean, I suppose was put in writing by the government with the rent housing task force originally, though even before that, having been part of the stakeholder meetings, it's been long advocated for by to be honest, actually all sides of the housing ecosystem. It's something that LandlordBC is advocated for in some levels, that the tenant advocacy groups have advocated for. Maybe not necessarily everything that has been added was advocated for, but definitely an expansion of those. Because as you said, Grant, I mean, they were pretty limited. I think the three before were you couldn't attend, you have new and relevant evidence, and the decision was issued by fraud through the other party committing fraud, which, you know, as you say, it's nearly impossible to prove that last one. New and relevant evidence, I mean, the reality is you generally have your evidence up front. It's rare to get something late in the game. It's not to say it doesn't happen. It certainly does occasionally happen, and I have seen it once or twice. I don't know that it was accepted through a review. So that's even rare. You know, the first one being you couldn't attend the hearing. Even that, you know, that was a strict guideline around that. Around, you know, it has to be pretty significant, which is understandable as to why, you know, you can't attend. So this expansion, you know, I think was likely motivated from the fact that it was in the rent housing task force recommendations. Additionally, I am sure that internally at the RTB, politically, there's a certain want to have less of their decisions questioned by the courts. You know, it makes more work for them in some ways, though it also puts more work on them as well. So they're probably kind of questioning if it was worthwhile. But yeah, I mean, this expansion is certainly, like I said, a long time coming. Likely multiple motivation points of motivation for that, but you know, some of it is certainly welcome. Being able to not have to go through that judicial review in some of those cases is certainly good. But the, you know, the other expansion on this isn't so much just that we have expanded grounds, but that the RTB can independently also see a decision and say, maybe there's a mistake here, we need to correct it. And they can independently make those decisions now to have a review of something without an application even coming in, which is good because, you know, arbitrators, they're people, and people sometimes make mistakes. And we have seen occasionally where a mistake has happened, and it was brought to the RTB's attention, maybe not by what the parties to the decision, and they can now actually go through and make that change independently and inform the parties that they've done that. So that's a pretty significant change, and something that allows for, I guess, a certain amount of self-accountability within the bureaucracy there itself.
Yeah, I mean, we've long argued that you know, the identical situation is presented to two different arbitrators and you get two different decisions. So invariably it's because one made a mistake.
Yeah.
And now this will allow them to self-correct. You know, I think this is something that they're going to continue to monitor and tweak as we go forward. But definitely, as Hunter mentioned, you know, ourselves and tenant advocates, you know, both have raised concerns about this. And, you know, it's good to see that they've done this now. It's going to create some efficiencies and I think result in some better outcomes for both landlords and tenants. Maybe shift this to Hunter here, and then Grant can probably jump in as well. So I think our members, or most of our members on the webinar here today, will have seen that there's a impending decision on vacancy control for SROs in the city of Vancouver, and maybe Hunter, you can just touch on that to share with our audience what that's about. You know, I guess the status of it as such. Would you mind doing that, please?
Yeah, certainly. So just to give perhaps a bit of background, some information just around what's led to this, where we are now. The city of Vancouver has decided or made a decision to, in its past council, to essentially try to cap rents of SROs, or single room occupancy units, or single room accommodations. So you might see the term SRO or SRA interchangeably when talking about this topic. And the idea is to essentially cap the rent between tenancies, so that it can only go up by the allowed percentage between tenancies as well. This is something that is obviously something that, you know, as an organization, we're opposed to. It's essentially vacancy control, and something that we have long advocated against, and government seems to have no appetite whatsoever to implement that from a provincial standpoint. But it does occasionally come up from a municipal viewpoint, and instead of implementing this industry-wide, they were focusing specifically on SROs. They created the bylaw. It was taken to court. It was struck down. It was said essentially, this is not valid. This is outside of the purview of the municipality. So Vancouver, essentially, what they said is the Vancouver, through the Vancouver Charter, doesn't have the authority to create this type of bylaw. The Residential Tenancy Act already exists. It pertains to residential tenancies, which SROs fall under, and this is essentially the municipality, the city, stepping outside of what their authority allows them to. Instead of accepting that decision from the courts, they've decided to appeal that. LandlordBC is an intervener in that process and delivered a factum on that, that outlines our opposition specifically to the fact that municipalities don't have that authority. It's an important case because this is a conversation that has happened in other municipalities. I don't know if I want to go through and name every one, or any in particular to not make enemies, but this is something that, it's on the table occasionally with municipalities, and we're confident that municipalities don't have that authority under their purview, but nonetheless, councils sometimes do choose to push that button, and so this decision, ideally is what will come from this is kind of a strong approach from the courts saying, no, this isn't the authority of the municipalities. This is covered by provincial legislation that is their purview, and as we know from our frequent and lengthy conversations with government, this is not something that is on the table for them. They're not interested in implementing what essentially would be an industry killer. I mean, really, we know what vacancy control would do to our industry. We know that more rental housing is needed, and vacancy control is not the way to get there by any means. So that is where we are. We've shared this in our emails in the past, and we'll of course obviously be keeping our members up to date as this gets processed. Where we are right now is again in that appeal process, where we have intervener status for that. Not expecting a decision on that today by any means. Not likely to the new year sometime.
Yeah. Grant, do you want to add anything to that?
Yeah, I think because our experience is widespread throughout the Lower Mainland and the province. So we have, or I have seen more and more interventionist work by local municipalities, local government. Now, I think the most experience I've had is in the nonprofit sector. So I work heavily in the nonprofit sector as well. Nothing really wrong with that. Municipalities want to maintain control of nonprofit housing, and they want to make sure it stays nonprofit housing. So they usually put covenants on the land when you're doing like developments and so on. If they want some funding, they'll attach agreements to it. But what I'm seeing is sort of a movement to try to to fill in gaps that municipalities think exist in the legislation, and they shouldn't be doing that. You know, there might be, you know, excess regulation regarding upgrades or unit upgrades or renovations to rental properties. 100 different hoops you have to go through if you want to like knock down a building and build something new. City of Vancouver is, you know, an example of someone who's, I guess, activist in this area, and their attempt to try to make rent control on SROs. City of New Westminster also same thing. They were successful in their bid for they did a zoning, which was successful. So I think that's emboldened the municipalities to maybe move more into this sector. It's only for certain municipalities. Not everybody has like municipalities would have large rental populations that vote. That's where you're going to see this happening, because it's more like almost like a political move. But they're somewhat emboldened by what they've seen New West and City of Vancouver doing. So I expect that they will try more of this. Whether or not they'll be successful, we'll see. I'm hopeful about the City of Vancouver SRO case. The difficulty there, of course, is from an advocacy point of view, is that we've always gone to the provincial government and said, well, you know, rent control is not a good idea. And I think we've been very successful with that. Now you're dealing with this gaggle of municipalities who do, and their approaches are diverse. Everyone's different. They've got a different idea of how they want to do certain things. How do you go after them? Do you go to UBCM, like that's the Union of British Columbia Municipalities, and start advocating with them about, you know, this rent control thing, or what? And so when I'm dealing with like the developments that I'm working on, and I every time if it's a different municipality, I'm looking at something different every time. The paperwork is different, the goals are different, the policy is different. And I have to remind myself for which municipality, like, what are their goals here, and what are the special rules these guys want, because it's always different. So when a client comes to me and says, well, I want to like, you know, renovate 24 units, and it's like a total gut, it's asbestos and all that stuff, I got to go, okay, well, I know what the rules are in City of Vancouver, but what are they in this municipality? And you got to go look it up. It's different every time, and so that's a problem. The warning, I think the thing is, like, we ought to be on guard for this. We have to be on guard for municipalities trying to extend their jurisdiction into what might end up being rent control for certain areas. I don't think they would do it like municipality wide, but they might try to target certain areas of their municipality by way of bylaws. What I think they might try.
Yeah, I mean, that's a great comment from both of you. I think I just want to mention that SROs are actually not our LandlordBC's constituency. You know, so I think that's important that I make that distinction. But you know, like I said, we pursued and were successful in gaining intervenor status, because this vacancy control concept, you know, has, if it were to be accepted there, runs the risk of broader implications at least within the, or potentially within the City of Vancouver anyway. But I do want to reiterate what Hunter said, in that, you know, the Premier and the Housing Minister have both been publicly on numerous occasions, including at our recent AGM, where the Minister Kalan and I did a similar fireside chat. He didn't even need prompting. He very quickly said to all in attendance that the province is not implementing vacancy control, and you know, he and the Premier both very knowledgeable on housing and rental housing. You know, they understand the huge negative consequences of vacancy control in terms of the operation and creation of new rental housing. So that's you know, that's great that they are that's their position. Nevertheless, you know, we continue to, you know, we're regular communication with the minister in particular, and you know, invariably, you know, before the conversation ends, I always try to make sure to mention vacancy control and say, hey, so nothing's changed, right? No vacancy control, and he laughs and says, no, nothing's changed. So we're gonna continue to do that. But nevertheless, I think really important, Hunter, that you touched on this to share with our attendees today. Okay, if I can move on, what is the costliest common mistake you've helped landlords with? And I don't know. Why don't we start with Hunter this time? Last time we started with Grant. We'll start with Hunter.
Okay. Yeah. I think that Grant and I will probably have the same answer on this. In fact, I know we're going to have the same answer on this because quite often it's me referring a member to Grant in his firm. So on this topic, but I say that the costliest one is the need to pay an additional 12 months compensation when a 2-month notice, generally speaking, when there are other notices that fall into this, but we'll focus on the 2-month notice, is improperly served. So served essentially not in good faith, it's not followed through with. A bit of kind of just understanding of what that is. The 2-month notice allows landlords to end a tenancy because they or a close family member, their parent or child, or parent or child of their spouse, is going to move into the unit and live there for at least 6 months, occupy it for at least 6 months. And that can apply to them. It can also apply to a purchaser of a property as well. So if you're selling a property and the new purchaser has requested that they have the unit vacant for the purposes of them, their spouse, or their close family member of them or their spouse to move in and again live there for at least that 6 months. That's the 2-month notice, then specifically what we're talking about. And that comes with 1 month's compensation, just general. You serve that notice, it's 1 month compensation. But if you end up not following through with that, the tenant could be entitled up to an additional 12 months rent, which I mean is not insignificant by any means. And in fact, the RTA understands how significant it is by allowing those applications to go through, even though they are higher than their monitor order cap. So it's possible that you know, you could end up being taken to dissolution for something that's higher than the monitor order cap, which is also happens to be the cap for small claims court as well. Again, it needs to be that you didn't actually use this. So if you have a legitimate bona fide need, you move into the space, you live there for that at least 6 months, ideally longer. You know, you're generally safe. You do have to prove that if the tenant disputes it, and the burden of proof is on the landlord. But I would say that, you know, occasionally it's going to happen where planning wasn't done in advance. It wasn't served with everything kind of worked out, and the landlord doesn't follow through with that. And in those cases, that's an incredibly costly mistake. One that there isn't too many ways out. I mean, the RTV does allow for a landlord to, you know, provide explanation as to why, and if you can show that you know, you didn't move in, you didn't live there for the 6 months, whatever it might be, for at least that 6 months, and that it was because of something that was significant outside of your control, then they can choose to not implement that. But again, the burden of proof there is high. And I know that, you know, quite often we get that call at LandlordBC. There's not much that we can provide in terms of advice other than explaining kind of the general process and what they're looking for and what the legislation says. Beyond that, when it comes to preparing for that, you may have to talk to a lawyer. So this is when of course Grant and Haddock and Company in general come into play.
Grant?
Yeah, I think about probably close to 50% of the inquiries we get are people who are either didn't get possession of the unit and they're perplexed, or lost, and now have to pay, like, in excess, it could be more than 35 grand, which is the limits. We got a few clients in West Van who, if you're renting a house for 6 grand a month, that's a lot of money. So it's and if you don't use it yourself, that's a lot of money. So it's sort of a different category. The concept is strange. Like, it's today's car accident is what I call it. Today's fender bender, because when you are successfully remove someone from your place because you're going to use it yourself, they're going to drive by in the next year or whatever, certainly the next 6 months. And if they don't see the lights on or whatever, they're just going to file. And why wouldn't they? It costs them nothing. There's like it costs the ex-tenant nothing to file. So why wouldn't you? And roll the dice. And we run into a few situations where a bad decision has happened. The landlord now has to pay 12 months rent. I looked at the evidence and I go, how can this be? Because every once in a while, adjudicators just get it wrong, or they don't believe you because it's all about good faith. And a lot of that is like, well, you have to show the arbitrator that this was all in good faith, and they might decide arbitrarily that it wasn't. And so I'll get these things and I'll go, well, your evidence was great on this, and but you lost. And now if you want to do a JR, it has to be patently unreasonable, which is a really high standard, and I can't say it is, because patently unreasonable means an adjudicator can be wrong about these things just as long as they follow certain rules. But so it's sometimes a really bad situation. There's not a lot we can do after the fact. So I've always said on these things, maybe you should talk to a lawyer before you actually go in there, because even though it makes sense to you that you can just say, oh, yeah, well, my grandmother's living there, and the adjudicator says, well, how are you going to prove that? And go, and you didn't think about it. And you go, well, and your grandmother really is living in there, and you didn't get the evidence you needed, and you're going to lose. And there's not much you can do after the fact about that. Maybe the review situation, but the JR is not going to work. So I think that we give people bad news all the time about this, and we go, yeah, we can do a JR on it, but do you want to spend all that money when we think you're marginally successful to do this? It just makes it worse. So we have people that, go away sad, and how am I going to do this? How am I going to pay this? And so that's just a warning, because there's not much we can do after the fact. We have solved some issues and solve some bad situations after the fact, but it's very expensive, and it's not always a slam dunk, and there's always nervousness about whether we can actually convince a Supreme Court judge this should be overturned. So really, the cautionary thing here is make sure you understand what it is you need to do. Make sure you understand what a relative is who's going to move in there. Make sure you understand that if you're going to take it over yourself, that you're going to use all that space yourself. When a tenant comes to you and is either fighting you to leave or is after you for rent, think about whether you really know what evidence you need to present to the arbitrator, and whether you're confident in going there yourself. And if not, call us. Call Hunter first, then call us.
Okay.
No,
Yeah, I think, I mean, Hunter can speak to this better than I can, but I think as an organization, we've been concerned about, I think some, not necessarily our members, recognizing there's a much, broader constituency of landlords out there who don't necessarily understand this 2-month notice, and what constitutes personal use and who's eligible, et cetera, and which is unfortunate. But I think there's also, one of the things that we're concerned about. We are seeing, I think, landlords need to act in good faith in this situation. I think that if they do and they have good documentation on it, then they're going to protect themselves. So that's also part of the message I think we as an organization always like to share. Um, uh, okay, I do want to say to our attendees, please put your questions into the Q&A. We are seeing a number of them coming in, but we'd like to get more. So if you have questions, please type them in the Q&A while we continue here. I guess, okay, what would you like to say to landlords contemplating issuing a 2-month notice? I guess we've kind of covered that off, have we not already?
Yeah. I mean,
Yeah,
I think
okay.
the core here is, plan in advance.
Yeah, for sure.
I could add something because we've been giving people advice on this because if they're doing this type of stuff, so we're telling them like, and like before and after the move, gather as much evidence as possible, like photographs, utility bills, moving bills, furniture placement, events, witnesses, in anticipation of a possible RTB proceeding. So my comment on that, okay, good advice to do that, like gather all your stuff, but why in the world do you have to do it in anticipation of an RTB claim? Because that's what's happening. Is like tenants know, and it's kind of widespread now. It's common knowledge that you can get your landlord for 12 months rent if you catch them out on this. It shouldn't be that way, but that's the way it is. It's like you're protecting yourself against anticipatory litigation. It's the craziest thing. He said people go, well, I'm just doing what I'm allowed to do. It says, well, yes, you are, and you might lose for being absolutely right in the right circumstances. So be careful. I just find that sort of ridiculous that you have to plan for litigation.
Yeah, well, this again, I'll just quickly add that this is an area that's certainly on the radar for the minister. Certainly, tenant advocates have been, out there educating tenants and are kind of very much behind what you just described, sort of, the frequency which they're basically telling all tenants who are impacted to, like you said, check to make sure the lights are on, et cetera, et cetera. I don't know, we're anticipating some conversations with the RTB and the minister here probably over the next 6-8 months on this issue, because they are very concerned about bad faith situations. But our position is that this is an important right that landlords should have, and that one that needs to be protected. And so we're going to continue to argue that, but there's definitely going to be we're anticipating more in-depth conversations in the early parts of 2024, because like I said, the minister himself has said he's concerned about this, and if the minister is concerned about it, that means he's someone within RTB is doing some research on it, and we will be part of those conversations. Okay, so landlords focus on compliance with the RTA, PIPA, Human Rights Code. Are there other statutes that landlords need to watch out for? Grant, why don't we start with you?
Okay, those are the main ones, of course, but there's Strata Property Act. This is more and more common now. You're renting in a strata corporation. So we had, some good news, I guess, is like they've done away with rental restrictions in strata corporations, so you don't have those any longer. But it's now a bit of a free-for-all. The idea is there's more strata properties on the market for rent. I don't know if that's true or not, but you do have to be, as a landlord, be careful about Strata Property Act laws and bylaws, and then what your tenant is doing, and you're responsible for what your tenant is doing, and you can be fined for what your tenant is doing, but you can pass those fines along. If your tenant does something wrong, you're entitled to a hearing before they can levy any fines. You have to be aware of that, but you actually have to ask for a hearing. Because if you think, for instance, like your tenant has done nothing wrong, you can fight it. So as an example, I've got one where the tenant's guest came out of the parking lot, but followed another car out of the parking lot, and the gate came down on top of the car and then bounced up. And so there was going to be a fine for damaging property because they said, well, the tenant hit the gate, the tenant's guest hit the gate. So my argument was, no, the gate hit the tenant. You're lucky that the tenant isn't like RICBC is going after you for this, so there shouldn't be a fine. So that's an example, a simple example of where you might want to be alert as to what's going on. Otherwise, you might be paying some fines for your tenants in your strata property. You got to watch out for local government. We've talked about that. What are the municipalities doing? How are they? What are they passing that might impact you that you don't know about? Because no one really pays attention to local government bylaws as they change. Then there's the new short-term vacation rental legislation that shouldn't impact our members because probably none of you are doing STVRs. But there's this other thing is like, well, will that create more rental stock? Probably mostly in City of Vancouver because there's a lot of strata corporations where people are operating STVR businesses out of. Will those turn into traditional rentals? Will that put more units on the market?
Hunter, you want to?
Yeah. Yeah, I think that that's the short-term rentals one is something that actually, it's not going to impact our members because they're not doing this, but it might impact them because their tenants might choose to use services such as Airbnb and such. And that's where I think we really do see these calls come in. Landlords concerned that their tenant is providing this or is using this type of service, which can cause, damage to the property, cause disruption to other occupants of the building. And then it can have financial implications as well when it comes to if this is in a strata that potentially issues fines. There can obviously be fines from the strata, but there can also be fines from the municipality. In fact, I had that call just recently where there are fines coming from the municipality because the tenant is renting the unit out on Airbnb, and that's a problem, obviously, for the landlord. They're working to address it. I think they're going to be able to work with the municipality to avoid fines, but nonetheless, there are real implications for that. It's something that we've talked about in the past. We'll talk about again. We actually have an event coming up in the new year where I'll be talking about how to deal with situations where a tenant is renting out the unit or a room in their unit, either way, on services such as Airbnb, and then we'll go from there. But it is something that certainly has an impact, as you mentioned, Grant, already. That this changes to strata bylaws, not being able to basically put any type of restriction on rentals. There's certainly a positive when it comes to opening up rental units. It does, however, it causes some friction because we're going to have strata corporations that are not, despite not being able to legally be unfriendly to rentals in their property, might nonetheless be unfriendly to rentals in their complex, and that's when we start seeing that type of friction, that's where problems come up. And you get kind of a sticky council that really doesn't want rentals in their property, but you've chosen to rent it out, which is your lawful right. It can get quite messy. So it needs communication is really key there. And we've also talked about that at length in kind of a webinar series with by Zoa over the past 2 months, and we'll continue over the next couple of months as well to kind of explore that relationship between landlord and strata council and such.
Okay. There's been recent media coverage of a situation where a landlord increased the monthly rent $600 for a newborn child. The couple were renting. I don't recall whether it was a house or what their current rent is, but they had a baby, and the landlord decided they wanted to charge up the rent $600 a month. My sense was that was a very, very significant amount relative to what they're currently paying. But I wouldn't mind getting your perspectives on this, and maybe Grant, if you don't mind, we start with you.
Sure. I don't know what the end result of that was, but if it's in the contract, then I suspect the landlord has the right to do it. To add, because the contract probably says, two people, that's it. And if you add a third person. So this has been in the media once in a while, mostly in the human rights context, because there would be an argument that that you're discriminating based on family status. Suddenly you've got children. The strata world has had a lot of that, and they had a like a no children bylaw, right? That's gone now, but they would have previously they have like age restriction bylaws. You can only have plus 55 now. You can't have anything else. But people had to sell their homes because they had a baby. I think there was a couple somewhere, it was in the news, I don't know how many times, but they had the baby and they literally had to sell their strata. So I don't know, if the landlord has the right to increase rent by $600 a person, and that's somehow in the contract, and it was known to the people who were having the baby. I don't know how they can complain. The media will print that stuff because they love it. But I don't know the other side of that. Like, did they know they had to pay $600 extra if they had the baby? If they did, well, then it's tough for them to complain.
Hunter, what are your thoughts?
Yeah, I think that this is a pretty solid right in the legislation to be able to have rent fluctuate based on the number of occupants, and there's some valid rationale behind that. Their expenses fluctuate depending on the number of people who are living in a unit, especially if you're covering things like utilities. As soon as we start covering things like water, even electricity and such, there's going to be additional costs for the housing provider. So being able to charge that higher amount, and have the rent go up by that amount, and they actually kind of separate it out. They don't even call it a rent increase in the legislation. They separate it from that entirely, so it's separate from the normal rent increase process. It's a valid right, and we certainly support that. $600 as an increase, obviously, to say that that's too much would require knowing more about the rental unit itself and what's being provided and how much the rent is. But I think if we're looking at kind of an average tenancy, it sounds quite high. It's generally the idea here is it's this increase in the amount is meant to cover additional expenses. So really people should be kind of using it as that if we're kind of using it in good faith. But yeah, it's a complicated topic for sure. And I think we can all kind of understand the concern that a new family might have with having this additional increase on a monthly basis. But it generally speaking, not generally speaking, technically speaking, for the landlord to be able to do this, it's in the contract. It's right there. It's very, it's front and center. And I think in this story they, said, oh, we thought that would be only if an adult who was, making money and could pay rent was moving in. It doesn't say that it's occupant in general. So that's perhaps maybe a lack of communication there. And I think that's a big part of this, is that we really want to make sure that landlords and tenants are communicating at the beginning of a tenancy, making sure that there's a certain amount of understanding on both parts, and that tenants are educated that this is a possibility, that rent can go up, and if you see an amount in there that you're not comfortable with, to address that at the beginning of the tenancy, or not enter into that specific tenancy.
Yeah. Okay, we're going to move on here. There's some other questions from our attendees. Okay, how can we encourage the RTB to translate the RTA into languages of the new immigrants that we are encouraged to rent to? It would have cost me $2,100 to get it translated into, I guess, the tenancy agreement, etc., into Arabic. I thought they don't have translation services. Their website maybe just the website, I guess it is, isn't it?
But even that, actually, so this is something that actually is a not a small issue. You know, we are a multicultural country for the better, and there are certainly language barriers that are going to happen, especially for people who are new to Canada or potentially have a refugee background. There is there's an impact there that is going to be felt because people aren't going to understand. And then, if we someone who's coming here from another country, especially refugee background, likely they're coming from a different housing environment in general. They may have spent the last several years in a refugee camp, and prior to that, within their country of origin, the structure of rental is probably very different than what we have here in Canada, especially in British Columbia. So, you add to that the fact that you hand them a piece of paper that's in a language they don't understand, and uses words that even if they understand, basic English, it's not simple. It's not, it's not written overly complicated, the legislation or the law, but it's so it is. I understand the concern. The RTB used to have its resources in multiple languages, and they actually stopped doing that a number of years ago. So it's an interesting thing. I don't. There are other services, and perhaps maybe that's what needs to be done is maybe not so much translating everything on the RTB website and the RTA and such, but rather linking to
different
translation services that perhaps maybe are more cost effective as well. I know that a lot of intercultural.
I think it's something that we can touch base with the RTB, perhaps, just to say that this has been an issue raised. I want to keep moving on here for a few more questions, okay, Hunter, because we're running out of time. I guess the province passed some legislation about rodents and what kind of I don't even know what they're called. I guess stuff they can use to kill rats. And rodents are a huge situation in Vancouver. Vancouver is right up there, with the rat capitals of North America. Hunter, are you hearing much from our members in terms of concerns about the ineffectiveness of the products that they are allowed to use or their suppliers are allowed to use?
Pest control is certainly not a minor issue by any means. I'd say that when it comes to the chemicals that we use and the kind of strategies that can be used, it's less about rodents being the concern and more about pests. So things such as bed bugs, for example. Treatment on that is not ideal. It's probably for our health that it's not ideal. So that's a difficult one to address because a lot of the rules that are in place that stop us from being able to use the chemicals that are quite effective are also quite effective at harming us. So yeah, it certainly is one that we have heard more from the pest side than rodents, especially given that rodents, the approach can be more robust, including traps and such, and you have a good robust kind of program in that place, and tenants that are complying, generally it can be helped with, especially with maybe some building improvements to blocking paths of access to the building for rodents, whereas pests such as bed bugs, that's kind of a lottery as to whether it's going to happen or not.
Right. Okay. Here's a good question. How can a landlord get more rent when a tenant has been in the unit for 13 years and is paying well below market? Yeah, there's the example of what they're currently paying versus market. I guess that's a question that maybe Hunter, you want to start with that, and then Grant can jump in?
Yeah, well, I mean, maybe I can start with just talking about I mean, in British Columbia, we have, of course, we do have rent control in terms of, we don't have vacancy control. We have rent control within tenancies. And you know, sometimes that allowable increase, especially on years where the government has chosen to intervene on the amount, is not keeping up with the cost of running the business, cost of conducting you know, capital expenditures, for example. So it can be difficult, certainly. There are a couple avenues for landlords to kind of investigate when it comes to increasing rent above the allowed percentage. The first would be to cover the costs or the expenditures of capital projects in the building. So if you were to conduct you know, large scale work on a property, placing a roof, work on the elevator, and this is for any type of unit. So it's small, you know, this can be a house, it could be an apartment building. But if it's, you know, the major systems of that property, and you're replacing it because it's end of life or it's broken, or it's going to improve the energy efficiency of the building, you know, there is the option of being able to apply for a rent increase that gets tacked on top of the annual increase as well. And the process is fairly transparent. It's fairly straightforward. Something that we've talked about to our members in the past. We'll continue to do so in the year we're looking at getting some more resources on that. But you know, what's kind of great about it is that you can determine how much you've spent, go to the RTB website, put in the amount, put in the number of units that are in that building. So you know, even if it's just 2, that's fine. And you'll get back essentially how much you're going to get out of this, or potentially could get out of this process, so long as you meet all the criteria, which are pretty well laid out. You should be successful. It's not a small amount of work by any means, but it's also not particularly difficult. It's mostly just kind of gathering information that you really should already have. You know, receipts and you know, reports about the work that's being done and why it needs to be done. Grant, have you been dealing with any of those?
I have not. I mean, it's not not that I'm aware of. We do a lot of it in the manufactured home park arena because it's easier as far as I'm concerned, and they have actually decent like good like infrastructure projects. They the regime there has been it's much easier there. But we you know, no, I don't think, I mean, I've had inquiries, of course, people asking us about it, and but no one, as far as I know, no one's retained us lately to do that sort of thing. And I think probably because it's costly to get lawyers involved, and I don't think someone told me it's really easy to get like rent increases doing that. I didn't think
it
it
is.
It is.
Is
Yeah,
it?
and I think that
Okay,
might be why.
Yeah.
Okay. Yeah.
Yeah, we're gonna be doing tutorials on this because it's right now our larger members are very successfully using the ARI process, and it's equally applicable to small landlords, including people with basement suites, you know, doing CapEx investments. So it was taking, as when it was first implemented, it was a very slow process at RTB. They've since really, you know, improved their whole process in terms of, you know, getting these through very quickly. It's all very clearly defined, and plus the additional resources I think have helped with that. But yeah, all our members should be very closely looking at the additional rent increase process, and they're making capital expenditures. This is a tool to recover a portion of those. So, okay, we're 11:20. We're winding this down 11:30. Is that correct, Hunter?
Yeah. So we have time for a few more questions. While you maybe take a look, I'll just quickly mention. I saw a question that came in about whether or not the replacement of a well might be considered a capital expenditure, and you know, that I think that highlights the fact that this is available to landlords across the province. It doesn't matter if you have 1 unit, you know, a couple hundred units in the building, or if you're in Vancouver, or you know, a small town or village for that matter. You know, rural properties apply as well, and I think a well, you know, on a rural property is part of the water infrastructure, and generally speaking, it sounds like that actually probably would meet the criteria for a capital expenditure. And of course, well replacement isn't inexpensive by any means, so that's certainly something to investigate.
Certainly in the manufactured home park world, it is.
Yeah,
exactly.
Yeah, absolutely. Yeah. Okay, I'll just read this as it's typed, are our LandlordBC 1-year tenancy contracts subject to the annual percentage increases set by the BC government? The answer's yes, I guess, but
Yes.
okay,
Yeah.
but it says 1-year tenancy contracts. Is
Yeah,
that?
I think
I'm
that's
not sure what the. Go ahead.
yeah. I think that I can touch on that. I mean, that's something that you know, we occasionally get questions about is how rent controls and fixed terms interact. So, you know, one
Oh,
year, we talk about things like a 1-year contract, a 1-year lease. It's a tenancy agreement that just so happens to have a term of 1 year. And it'll likely be longer than a year in most cases. So once, no matter what type of tenancy you've really entered into, whether it's a month to month or a fixed term tenancy, and that fixed term tenancy could be a year, it could be 2 years, it could be longer. I don't generally recommend going longer, though there may be situations where it's applicable. You can increase the rent in those situations, and you can increase it by the allowed percentage, and it is tied to that. So you can't increase it more unless, of course, we look at those other processes that I mentioned, the capital expenditures as being one of those. Yeah, there's no other rules that apply if you have a 1-year fixed term, a 2-year fixed term, or a month to month. They're all essentially the same when it comes to rent increases.
Yeah. Okay, this will be the last question. I'm actually going to take it here. It says, how can we help to counter the recent BCGEU, which is the BC Government Employees Union campaign on Facebook to urge people to lobby for vacancy control, which is tying rent control to the unit? Don't want to be disrespectful to the BCGEU. We know that many of our members, belong to that union. I guess, the way we look at situations like this, a couple of ways as an association is, first of all, I guess we're really surprised that this particular BCGEU has decided to engage in this issue because, their pensions are highly dependent on how successful the real estate portfolio that generates or should generate significant returns to basically ensure that those pensions are properly funded, and the real estate entity that invests in real estate, handles all the real estate investment for the government pension plan, is actually a member of LandlordBC, and they share all the concerns that we have about how difficult it is to operate rental housing on a profitable basis, and they, like us, very much support all the advocacy we do to ensure vacancy control never happens in this province. So there's that disconnect there that is always confusing. But the reality is there's a lot of stuff on Facebook from a whole broad range of different stakeholders, and for us to engage all of them or on that platform or in the public domain on whatever issue they may be raising, a lot of times it's just a fool's game. There are specific stakeholders and advocates out there who are looking to have us take the bait, so to speak. And we have a lot of knowledge about media relations, government relations, and we spend a lot of time advocating directly to the government, and we do stuff in the public domain too, obviously, but we're very selective. We pick our battles in the public domain, and this one with BCGEU, there's no value in us going down that path. And like I said, it's a little confusing as to why they decided to advocate on this issue, but we're not going to engage with them on Facebook or social media. And again, to reiterate, the Premier and the Housing Minister both said that the province is not interested in implementing vacancy control. Okay, so we are kind of out of time for the questions. We need to wrap up the balance of the program here. So first of all, I want to thank Hunter and Grant for your excellent input and responses to the various questions. I want to thank Rona again for being our sponsor and remind everybody, to take advantage of the VIP program. If you're not a member, you hopefully will have taken down the email address to get a hold of Natalie. And then, I just want to thank you for attending and contributing to this charity webinar. That's allows us to donate $10,000 to Covenant House, which is outstanding. So with that, I'm going to turn the podium over to Hunter, and I guess you're going to do draws, correct, Hunter?
That's correct. Yeah. So again, thank you, Grant, for participating today. That's really, really appreciated. So our donations that came in from you, our attendees, our participants today, total $4,800, which with our matching funds, which I said we're gonna, as David mentioned, we're gonna top that up to bring it to a total of $10,000. Every dollar matters in this vital cause, and so thank you, on LandlordBC, for your generosity. As mentioned, in recognition of your support, each donor has been entered into a draw for one of two $50 Rona gift cards. And then for those who have donated more than $100, we are going to have an additional draw for a pair of Canucks tickets donated by Haddock Co, which thank you again, Grant, for that, in addition to the $1,000 you donated as well. So we'll start the draw for Rona cards. They've been selected at random. The two Rona cards go to, and I apologize if I've mispronounced your names, I really do, Satu Farrar and George Wire. So again, we'll reach out to you for that, to redeem those prizes. And now we'll get to the pair of Canucks tickets donated by Haddock Company. The winner of that is Paul Janis of Janis Industries. So thank you so much for attending. I believe all those people are here today on the call, so that's great. And again, we'll reach out to you for redemption of those prizes. Thank you to everyone who donated, and thank you for your questions today.
Yeah, great. So with that, we'll sign off, and just from myself and our team here at LandlordBC, we'd like to wish you and your families, all the best this holiday season. Hopefully you all have a wonderful holiday season. And while certainly these are challenging times, I think, we can all be thankful for the good things that are happening in our respective lives, and there's cause to be optimistic for 2024. We feel very confident here at LandlordBC. It's going to be a very good year. And so I want to wish you and your families a happy new year as well. So thank you again for joining us today. Happy holidays.